बिस्मिल्लाहिर्रहमानिर्रहीम। अस्सलामुअलैकुम। प्रोफेसर होला सदीकी एडवोकेट और पाक लॉ गाइड के चैनल से खुशामदीद। एजुकेशनिस्ट, सर्टिफाइड काउंसलर, ट्रेनर, सोशल राइट एक्टिविस्ट, एक दफ़ा फिर आप सबकी खिदमत में पाक लॉ गाइड की टीम हाजिर है। पाक लॉ गाइड का ये चैनल खसूसी तौर पर कवानीन और हकूक़ से आगाही हासिल करने के लिए डिज़ाइन किया गया है, जिससे ना सिर्फ तलबा बल्कि आम शख्स भी कवानीन पाकिस्तान के मुतालिक भरपूर आगाही हासिल कर सकता है। एक नए टॉपिक पर आज जानकारी हासिल करने से पहले सब्सक्राइब करना और बेल आइकन दबाना मत भूलें। तो चलते हैं आज फिर एक नए टॉपिक की तरफ।
Stamp Act, 1899. History and background. The Stamp Act of 1765 was the first internal tax imposed directly on American colonists by the British Parliament. The Act imposed a direct tax on printed materials to be produced on stamped paper carrying an embossed revenue stamp. It came at a time when the British Empire was deep in debt from the Seven Years' War, 1756 to 1963, and looking to its North American colonies as a revenue source. In 1797, the British government imposed this act on undivided India. First, it was imposed on Bengal and after some time on Madras and Bombay also. With the passage of time, this act got amended in 1860. Then it was further amended in 1899 and imposed all over India on 1st January 1899. After independence, this act was applicable in Pakistan for the purposes of defining and regulating the instruments which are chargeable with duty, for recording of transaction, and consolidates and amends the laws relating to stamps. Introduction. Stamp Act is a fiscal statute. Its object is to collect revenue for the state. Its object is just like the Court Fee Act, an income tax ordinance. The revenue that is collected and imposed by the Stamp Act 1899 is called stamp duty. The stamp duty under the Stamp Act is imposed on transactions which is effected or executed by through an instrument. Stamp Act 1899 prescribes that what transaction and instruments shall be liable to stamp duty, and at what rate such stamp duty shall be imposed. Explanation. Besides it being a fiscal tax statute, its object is also to secure the rights of the contracting parties from rival claimants and other subsequent illegal transaction. An instrument which is duly stamped, after that it is legally become capable for registration under the Registration Act, 1908. The proper time for stamping an instrument is when it is duly executed by the parties and signed by the parties. So, the proper time for stamping an instrument is after its execution and before its registration. An instrument which is stamped in the manner above is called duly stamped instrument. What is stamp? Stamp paper and stamp duty is paid when buying real estate or a home, acquiring shares, seeking a mortgage, or conducting other financial transactions. The attorney, company or broker that is involved in these transactions can tell you which documents require stamping. Agreements and contracts should be made in writing on stamp paper to have legal value, and it can be presented as evidence if needed. The stamp duty that are applied provided for instruments are in the shape of a document which are in the nature of adhesive stamp or impressed stamp. When and where stamp duty is required? Stamp duty is generally imposed on transfer of property, shares, debentures, bill of exchange, conveyance deed, hire purchase, promissory note and movable and immovable assets, partnership deed, gift deed, lease agreement, rent agreement, increase in authorized capital, agreement of sale, buying a house, bank guarantee, commercial property, home loan, loan agreement, mortgage. In real estate transaction that involves buying, selling, renting, and leasing of a residential or commercial property. The stamp duty of required value should be paid before signing it, as the documents cannot be used presented in a court unless properly stamped. Who determines the value of stamping? According to the Section 13 of Stamp Act, the value of stamp will be determined by the collector. Collector is a district officer, revenue, or any officer appointed by provincial government in the official gazette. To determine the value of stamp, the collector must be provided with an abstract of the instrument with affidavit or other evidence which is necessary. Difference BW stamp paper and stamp on property documents? The stamp paper is a paper having printed revenue stamp of specific value such as Rs. 50, 100 rupees, 500 rupees, etc. by government. Generally, all important transactions like buying, selling or renting of any property shall be done on stamp paper. The stamp paper is also used for giving power of attorney or doing any type of agreements containing financial deals, contracts, affidavits, declaration. There are 14 different varieties of stamp papers available in 10 denominations. They are of two kinds: judicial, used for legal and court work; non-judicial, used for registration of documents, insurance policies, etc. Judicial stamp paper. Judicial stamp papers are generally used for a legal purpose or for court cases. The judicial stamp papers are also commonly known as court fee stamp paper. The judicial stamp papers are used for payment of court fee in the court to avoid cash transactions. The case may not be admitted without payment of court fees. Now, when you are lodging any civil plant or a complaint under the Negotiable Instruments Act, you have to pay court fees which are proportionate to the amount of your claim. Non-judicial stamp paper. Non-judicial stamp papers are generally used for documentation like power of attorney, sale deed, rent agreement, affidavits, transfer of immovable property like building, land, mortgage or other important agreements, etc. At present, the non-judicial stamp papers of value are 20 Rs, 50 Rs, 100 Rs, 500 Rs, 1000 Rs, 5000 Rs, 10,000 Rs, 15,000 Rs, 20,000 Rs, 25,000 are available. What is revenue stamp? A revenue stamp is used to collect taxes or fees. Revenue stamps are added to products or relevant documents to signify payment of a fee. Pakistan first issued revenue stamps when it became independent in 1947 and continues to issue revenues to this day. In addition to national issues, the provinces of Balochistan, Khyber Pakhtunkhwa, Punjab, Sindh, as well as Azad Jammu and Kashmir and the capital Islamabad also have or had their own stamps. The province of Sindh's first revenue stamp issues were in 1971. Since that year, stamps have been issued annually to pay for the following: arms license, driving license, motor vehicles fitness certificate, motor vehicles tax, route permit. The Stamp, Sindh Amendment, Ordinance, 2002. The Sindh government on 7 May 2002 approved the promulgation of Stamp, Sindh Amendment, Ordinance 2002. The decision was taken by the Cabinet to reduce stamp duty on financing documents from 1% and bifurcated into following 4 categories for levy. Where the amount does not exceed 0.2% or 1,000 rupees. 1 million rupees, whichever is less. Where the amount exceeds 0.2% or 2,500 rupees. 1 million rupees but does not exceed, whichever is less. 10 million rupees. Where the amount exceeds 0.2% or 5,000 rupees. 10 million rupees but does not exceed, whichever is less. 100 million rupees. Where the amount exceeds 0.2% or 10,000 rupees. 100 million rupees. Whichever is less. it was felt that rates of stamp duty were horribly low and favored the rich. Also, it was discriminatory and disproportionate to other rates of stamp duty, which needed urgent correction and rectification. Sindh Cabinet agreed on deleting 34 out of 65 articles reflected in the Schedule of the Stamp Act of 1899 through the same Stamp, Sindh Amendment, Ordinance, 2002. Stamp, Amendment, Ordinance 2020. The federal government has announced a relief package for the construction sector in Pakistan by amending Stamp Duty Act 1899 and enacting the Stamp, Amendment, Ordinance 2020 i.e. reducing stamp duties in various transactions. Certain instruments have been reduced in the following manner. The stamp duty on certificate of sale, conveyance, decree, release, exchange and gift of immovable property has been reduced from 5% to 1%. The stamp duty on a settlement in the instrument has been reduced from 3% of the value of the property to 1%. Transfer of lease and transfer of right or interest relating to immovable property has been reduced from 5% of the value of the property to 1%. The above changes brought about by the government attempt to enable the construction sector to experience rebirth in the time of a global pandemic. These amendments will provide relief to people looking to purchase immovable properties in urban areas without being charged excessive stamp duties as before. It will also help stabilize the economy and increase investment in the country in this crucial period of pandemic. Stamp Amendment Act 2021. Apart from various important amendments introduced via the said legislation, one of the most important additions have been amendment of Section 40 of Act 2 of 1899. In the Act, in Section 40, for subsection 1, the following shall be substituted. 1. When the collector impounds any instrument under Section 33, or receives any instruments sent to him under subsection 2 of Section 38, he shall adopt the following procedure. If he is of the opinion that the instrument is duly stamped or is not chargeable with duty, he shall certify by endorsement thereon that it is duly stamped, or that it is not so chargeable, as the case may be. If he is of the opinion that such instrument is chargeable with duty and is not duly stamped, he shall require the payment of the proper duty or the amount required to make up the same, together with a penalty of maximum 10 times the amount of the proper duty or the deficient amount thereof, but not less than 2 times of the amount due. Provided that when such instrument has been impounded only because it has been written in contravention of Section 13 or Section 14, the collector may, if he thinks fit, remit the whole penalty provided under this section. Provided further that in case of any purported transfer of right, title or interest in an immovable property effected by a relevant public office in its record under an instrument which is not registered under the Registration Act, 1908, 17 of 1908, such instrument shall be chargeable with duty which shall be 10 times the amount of the deficient duty. Stamp instruments. Gift deed. When a person transfers property in favor of another person by gift and executes gift deed in favor of that person, so such gift deed is also an instrument as defined in the Stamp Act, 1899, because by this deed instrument the right in the property is transferred in favor of donee. So, such deed instrument shall be stamped. Such stamp duty on such gift deed instrument shall be paid according to the amount ratio as specified in serial item number 33 of the Schedule number 1 of the Stamp Act. Exchange of property. If owners of properties exchange said properties with each other and executes exchange deeds in favor of each other, such exchange deeds are instruments also as each person extinguishes his rights in favor of another, and at the same time each one also require rights in exchange, therefore exchange deed instruments are liable to stamp duty. Such stamp duty is to be imposed at the rate as specified in item serial number 31 of the Schedule of Stamp Act. Exchange deeds are instruments also, as each person extinguishes his rights in favor of another, and at the same time each one also require rights in exchange. Therefore, exchange deed instruments are liable to stamp duty. Such stamp duty is to be imposed at the rate as specified in item serial number 31 of the Schedule I of Stamp Act. Lease deed. Lease transactions are if effected through deed, whereby one person transfers his rights in the property for a specified period in favor of another person, so the leaser extinguishes his rights. Such leaser deed also fulfills the definition of an instrument as defines in the Stamp Act as an instrument of lease which is liable to stamp duty. Such stamp duty on lease deed instruments shall be imposed according to serial item number 35 of Schedule number 1 of Stamp Act. Partition deed. Partition or family settlement is the distribution or settlement of the joint property between co-sharers, whereby some co-sharers acquires certain property and at the same time extinguishes his rights in same joint property in favor of another co-sharers. Such private partition or settlement, if reduced into writing, is also an instrument, because each party in consideration of the acquisition of property in private partition also extinguishes his rights in the remaining joint property. An instrument of partition is liable to be stamp duty which is payable according to ratio amount specified in item serial number 45 of the Schedule I of the Stamp Act. Mortgage deed. Mortgage of the property has been defined in the Transfer of Property Act, that mortgage is a transfer of property for the security of loan amount advanced, with the condition that after the repayment of said loan, such property shall be delivered back to the owner. If mortgage deed is executed, such deed limits the rights of the real owner mortgager in his property, which fulfills the definition of instrument as defined in the Stamp Act, i.e. an instrument includes every document by which any right is created, transferred and limited, etc. Therefore, mortgage deeds are also liable to stamp duty. Such stamp duty is payable at the rate specified in serial number 40 of the Schedule No. I of the Stamp Act. Bill of Exchange. Bill of exchange is a document by which one person accepts his liability for the payment of an amount, which creates the right to receive the payment from the debtor in favor of creditor. Therefore, Bill of exchange is an instrument as per Stamp Act, as such is liable to stamp duty. Stamp duty upon bill of exchange is payable according to the amount specified in serial number 13 of Schedule I of Stamp Act. Promissory note. Promissory note is also an instrument under the Stamp Act, as the debtor undertakes his liability of payment to the creditor, as such is liable to stamp duty. Stamp duty on promissory note is payable as per ratio specified in serial number 49 of the Stamp Act. Power of attorney. Power of attorney is a document whereby one person principal transfers certain rights with respect to his property, is an instrument, and is chargeable to stamp duty as per item number 48 of Schedule I of the Stamp Act. Partnership deed. Partnership has been defined in Partnership Act 1932, which means the partnership is the relation between persons who have agreed to share the profits of the business carried on by all or any of them for all. The deed between the partners is, if executed, is termed as partnership deed, which is an instrument and chargeable with stamp duty as per item number 46 of Schedule I of the Stamp Act. Prerequisite conditions for imposition of stamp duty. Though the above-mentioned instruments deeds are liable to stamp duty, but there are some basic conditions which must be satisfied before imposition of stamp duty. These conditions are mentioned in Section 3 of the Stamp Act, which are as under. The instrument shall be executed in Pakistan. If the instrument is executed out of Pakistan, it shall relate to the property or matter within Pakistan. There is no stamp duty on instruments by or on behalf of or in favor of the government. There is no stamp duty on the transfer or disposition by mortgage of any ship or vessel registered under the Merchant Shipping Act 1894 or registered under Registration of Ships Act 1841. Stamp duty on several instruments used in single transaction. According to Section 4 of the Stamp Act, when there is a single transaction of sale, etc., between the parties, but for such single transaction several instruments are executed, in such a case the principal or main instrument shall be chargeable with the full duty prescribed in Schedule I of the Stamp Act, whereas the other instruments shall be chargeable with a duty of 4 rupees instead of full duty prescribed in the first schedule. For example, when the property is sold by A in favor of B and A executes an instrument of sale in favor of B, but at the same time B also executes a deed in favor of A for giving some time to A for the use of possession of that property till full payment of sale consideration, so the deed executed by A is the principal instrument chargeable with full duty of stamp, whereas the deed executed by B is not principal instrument is chargeable with stamp duty of 4 rupees. Stamp duty on single instrument containing several distinct matters. According to Section 5 of the Stamp Act, when a single instrument contains several distinct matters, in such a case the stamp duty shall be paid with aggregate of such matters. It means that whatever stamp duty is provided for each matters in the Schedule I of the Stamp Act, total amount of such stamp duty shall be chargeable on such instrument. Power of provincial government to reduce, remit or compound duty. The provisional government US 9 and 9- is empowered to reduce or remit the whole or any part of the stamp duty. Use of adhesive stamps and its cancellation. According to Section 11 of the Stamp Act, adhesive stamp shall be used upon the bill of exchange, promissory notes, entry as an advocate on the rule of High Court, notarial acts and transfers by endorsement of shares in any incorporated company or other body corporate. But it is noteworthy that an adhesive stamp, when has been executed affixed by any person on any instrument, shall cancel the same so that it cannot be used again. For example, adhesive stamp is cancelled by crossing it, or signing the same, or writing executant's name on it. Legally adhesive stamp, if not cancelled, the same instrument shall be deemed as unstamped and not legally admissible. Use of impressed stamps. According to Section 13 of the Stamp Act, every instrument written upon paper stamped with an impressed stamp shall be written in such manner that the stamp may appear on the face of the instrument and cannot be used for any other instrument. Time of stamping instruments and valuation of duty, stamp duty. According to Section 17 of the Stamp Act, all instruments chargeable with stamp duty, when it is executed by any person in Pakistan, shall be stamped before or at the time of execution. According to Section 18, every instrument executed out of Pakistan may be stamped within 3 months after it has been first received in Pakistan. Valuation of duty, stamp duty. A situation may arise that an instrument contains money value or consideration in foreign currency. In such case, the foreign currency shall be converted calculated to Pakistan currency at the current rate of exchange on the day of instrument, and the duty shall be charged on such money according to Section 20 of Stamp Act. B. When an instrument is chargeable with duty in respect of stock or any marketable or other security, such stamp duty shall be calculated on the value of such stock or security according to the average price or value thereof on the day of the date of the instrument. C. If principal amount and interest is mentioned is an instrument, the stamp duty shall be charged only on principal amount, and the interest shall not be chargeable with stamp duty as per Section 23 of the Stamp Act. D. Where the property is subject to mortgage is transferred sold in favor of the mortgagee, the mortgagee shall be entitled to deduct from the stamp duty payable the amount of any duty already paid in respect of the mortgagee. Section 24 of the Stamp Act. Stamp duty by whom payable. Section 29. In absence of any agreement to the contrary, in case of instruments of bill of exchange, indemnity bond, mortgage deed, promissory note, transfer of shares in incorporated company, the expenses of providing the proper stamp duty shall be borne by the person drawing, making or executing the instrument. In case of exchange of property, the stamp duty shall be paid by the parties in equal shares. In case of partition instrument, stamp duty shall be paid by the parties in proportion to their respective shares. In case of sale, the stamp duty shall be paid by the purchaser. In case of lease of the property, the stamp shall be paid by the lease. Evidentiary value of unstamped instrument. According to Section 35 of the Stamp Act, when an instrument required by law to be stamped is not so stamped, such instrument is inadmissible in evidence, shall not be registered or authenticated by any person or public officer. Examination and impounding of instruments. Every person having by law or by the consent of authority receive evidence and person in charge of public office except an officer of police before whom any instrument is chargeable in his opinion with duty is produced or come in performance of his functions shall if appear to him that such instrument is not duly stamped impound the same. For the purpose of this section, in case of doubt, the provisional government may determine what officers shall be deemed to being public office and who shall be deemed as person in charge of public office in this regard. Special provision as to unstamped receipts. According to Section 34 of Stamp Act deals that when any receipt chargeable with duty is tendered or produced before any officer unstamped in the course of the audit of any public account, such officer may, in his discretion, instead of impounding the instrument, require a duly stamped receipt to be substituted therefor. Agreement which I is unstamped or I is not properly stamped. Subject only to disabilities specified in S.35. Disabilities can be removed in manner prescribed in S.35 and 36. It is wrong to contend that an instrument becomes invalid if it falls within mischief of S. 35. An object of legislature in enacting Stamp Act was to protect public revenues and not to interfere with commercial life by invalidating instrument vital to smooth flow of trade and commerce. Merely because an instrument cannot be admitted in evidence for any purpose or because it cannot be acted upon by persons specified in S.35 does not mean that such an instrument is invalid. Decree passed by trial court in favor of plaintiff on insufficiently stamped document. Decree challenged by defendant with contention that decree was not legally sustainable as it was based on insufficiently stamped document in violation of S.35. High Court upholding the decree directing plaintiff respondent to make up the deficiency of stamp duty on insufficiently stamped document, which was basis of decree. Sections 35 and 36 come into play only when document is required by law to be stamped, but it is not duly stamped. Hence, provisions of SS 35 and 36 would not apply to documents not required by law to be stamped. Section 36 Admission of instrument, where not be questioned. Where an instrument has been admitted in evidence, such admission shall not be called in question at any stage of the same suit or proceeding on the ground that the instrument has not been duly stamped except as provided in Section 61 of the Act. Meaning thereby appellate court was bound to hold that admission of document was proper as nothing could be done at appellate stage. All the documents, whether stamped or understamped or unstamped, when once admitted would preclude any controversy on this point except the extent committed under Section 61 of the Stamp Act 1899. Revision of certain decisions of courts regarding the sufficiency of stamps. Most relevant sections related to court proceedings. Sections 33, 34, 35, 36, 37, 59, 60 and 61. Revision of certain decisions of courts regarding the sufficiency of stamps. When any court in the exercise of its civil or revenue jurisdiction, or any criminal court in any proceeding under Chapter 12 or Chapter XXXVI of Code of Criminal Procedure, 1898, makes any order admitting any instrument in evidence as duly stamped or as not requiring a stamp or upon payment of duty and a penalty under Section 35, the court to which appeal lies from or references are made by such first-mentioned court may, of its own motion or on application of the collector, take such order into consideration. If such court, after such consideration, is of opinion that such instrument should not have been admitted in evidence without the payment of duty and penalty under Section 35 or without the payment of a higher duty and penalty than those paid, it may record a declaration to the effect and determine the amount of duty with which such instrument is chargeable, and may require any person in whose possession or power such instrument then it is produce the same, and may impound the same when produce. When such declaration has been recorded, the court recording the same sends same the copy thereof to the collector, and where the instrument to which it relates has been impounded or is otherwise in the possession of such court shall also send him such instrument. The collector may thereupon, notwithstanding anything contain order admitted such instrument in evidence, or in any certificate granted under Section 42 or Section 43, prosecute any person for any offence against the stamp law which the collector considered him to have committed in respect of instrument. Provided that, except for the purpose of such prosecution, no declaration made under this section shall affect the validity of any order admitting any instrument as an evidence or any such certificate granted. Section 42. Importance of Stamp Act. Stamp duty is the tax governments place on legal documents, usually in the transfer of assets or property. Governments impose stamp duties, also known as stamp taxes, on documents that are needed to legally record certain types of transactions. This includes legal documents recording marriages, military commissions, and the sale or transfer of a property. It is an orderly and voluntary contribution towards the government which culminates in the sanctifying, legalizing, and legitimizing of due process of transactions. It confirms an act as lawful, legal, and with full force of the law. It also confirms the rights of both the parties involved in the said transaction.
जी डियर फेलोज़, आज का टॉपिक मुकम्मल हुआ। चलते हैं इस वादे के साथ कि इंशाअल्लाह ताला हमारी अगली वीडियोस में भी आपको मुकम्मल और आसान तरीके से लीगल गाइडेंस प्रोवाइड की जाएगी। अपना ख्याल रखिए, दुआओं में याद रखिए। पाकिस्तान जिंदाबाद।